afternoon, everyone, and welcome. My name is Ian Quell from IQ Legal Training, and I'm delighted to be working today with my friends at Legal Brokers and Stewart Title, who have sponsored this EPD event, which will last approximately 1 hour and which involves property fraud. Bit of housekeeping before we start. This webinar is being recorded. You can see a copy of the recording by contacting us at the end of the event. There are also some notes that accompany today's presentation, and if you'd like the slides, we can arrange for both slides and notes to be made available to you. A massive thank you, first of all, to Stewart's Title, who have organised this event and who have arranged for sponsorship via Stewart Title and Legal Brokers, and of course a massive thank you to Legal Brokers too for coming along today. I will be talking about property fraud and issues for conveyancers relating to property fraud, but before I do that, first of all, the contact details for Stewart Title. Robert Kelly, my dear friend, can be contacted on the email address and on the telephone number shown on the slide. Robert, Stephen Smith, and the rest of the team at Stewart Title are there to support you and indeed support brokers such as Legal Brokers in connection with title issues. So if you have any title issues or problems, please contact Robert. But the star of the show today is Darren. Hi, Darren, who is from Legal Brokers, who's introducing his ID wallet product, which I had a look at earlier last week, and was really interested in that it has lots of different features that I will be touching on in my presentation. So Darren, if you don't mind, I'll happily man the slide deck for you, but if you could take people through the product, and then Darren, if possible, if we have any questions about the product at the end of my presentation, assuming everyone hasn't fallen asleep listening to me droning, you could perhaps intercept and deal with any questions relevant to the product at that time. But over to you for a moment or two, if that's all right, Darren.
Of course, thanks very much, Ian. Hopefully you can hear me okay.
Yeah.
Yeah, thanks very much for the introduction. My name's Darren. I'm from Legal Brokers, as Ian sort of mentioned. Here at Legal Brokers, we work exclusively with Stewart Title, but we've also launched a new product via our brand idwallet.com, which is very much relevant today and the webinar that's coming up in a couple of weeks as well. So I'm just going to take you through for a couple of minutes what our products include, how they work, and how they can be of assistance to you. So first of all, on screen, you can see that we have our ID Bronze products. This product is designed to be a very simple, quick and easy check. The purpose of it is to allow you to check the anti-money laundering of your client. It's really relevant if you've seen your client in person or if you've received your identification by post certification and the good old-fashioned methods of getting that directly from the client. If you're happy with your client, if you're happy you've seen them, this is probably the product for you. It doesn't require any involvement from the client whatsoever. You can simply log into the portal, input the client details, and the system within a few minutes will provide you with a check that is either pass, fail, or refer, and it will go through all of the elements that are relevant to anti-money laundering. So it'll check the client's name against the address and mortality, so it does tell you whether they're deceased or not, and it will also cover the PEPs and sanctions list. The PEPs being the politically exposed person, and obviously our good friend Nigel Farage has had a few issues with that in his bank account at the moment, so it is quite relevant. And it is important to say as well, the PEPs list is a monitored list, so if that does change at some point in the future, you will be made aware. As I say, it's a very quick and simple check that was designed. A lot of people that see their clients in person are happy with this one. And I think it is important to say, my understanding of the SRA regulations are that if you have seen your client in person, you should still do a check on their documentation to make sure it's real and do as much as you can to know your client. And this really is a very quick and easy way to do that. It has had some uptake as well from mortgage brokers and estate agents who like it because I think their regulations are actually a bit simpler than ours. But it does all that in the process of a check for you, and it's only £2.20 plus VAT. So like I say, if that is of interest, please let us know. We can move on to the next slide, and then we can look at our ID Silver products. Again, available via the portal at our brand idwallet.com. The Silver, this can be run via a mobile phone or your computer. By inputting the client's simple details, they'll receive a text message and an email, and they'll be asked to follow a journey which will upload their documentation and give you some, basically some confidence in the client and who they are. They'll be asked to confirm their personal details, and a simple AML check will be run as per the ID Bronze. They will then be asked to take a selfie, and the system itself will know whether that person is live. If there's any doubts whatsoever, it'll ask the client to do a specific movement, like tuck the chin or touch the forehead or something like that. And then it'll then go on to ask them to upload a photograph of their ID, and it has to be photo ID, so driving license or passport. It will then provide you with a report that goes into all the AML features of the ID bronze, but then will also give you a biometric check and confirm whether the person who took the selfie is the same as the person that is on the photographic ID. You will, in the report, actually get copies of the selfies and the ID documents themselves. So if you've got clients that are either a further distance, maybe outside of town, which nowadays most people do deal with national clients, this is a really good check. It gives you really good confidence and you know who they say they are. It's a really quick, easy onboarding tool. So some people who sat still waiting for certified documents, this is designed to make that process a lot easier, quicker and simpler. The report itself will give you a pass, fail or refer, and again we'll be on hand to help you out if we can do in any way, shape or form. And the idea behind it is that any solicitor can use this. Now if we just after you go on to the ID Gold, the next slide for us please, Ian. Now the ID Gold is more designed, and this is probably going to be of more interest to the people in the webinar today. This is specifically designed for conveyancers and law firms. The ID Silver, the one before, could be used by any department really. This particular Gold product goes one step further and is designed to be Safe Harbour compliant. Safe Harbour are a set of guidelines from the sort of government and the Land Registry about really what conveyancers should be doing. And if you do follow the guidelines, the Land Registry states that in the event that there is some kind of fraudulent activity or registration of a property, they won't seek recourse from the law firm that have followed those Safe Harbour guidelines. So it's really relevant in nowadays and a check that will keep you compliant. The journey for the client is very similar to that of the ID Silver. You'll follow the app where you'll confirm your details, take a selfie and upload a photograph of your ID. It will then go one step further and ask the client to upload a proof of address document. Now in a seller's journey, they'll be asked to upload two, one for the address where they live and one for the address that they are selling, which is obviously not always the same. You'll get copies of those documents. It will then take them on a further step and ask them to place their passport on top of their mobile phone. With the technology that's included, the app will then read the chip on the passport and let you know whether that matches the information provided. There's a clever bit of kit which I won't go into now, but essentially there's a way of the passport holding information on a chip by something called a hashtag, and that chip can then compare it to the passport and make sure everything matches. You'll then get a detailed report confirming all of the details, so you'll get all the information that's included in ID Bronze, i.e. the AML check, ID Silver, so the liveness, and the biometric check, and then one step further, it will give you an NFC chip read to confirm whether it's passed or failed. And from there, you can have pretty complete confidence that the client is, or you've done as much as you possibly can to confirm who the client is. I'll be quite happy if you want to get in contact with us. My name is Darren, it's darren@legalbrokers.com. Anybody that's registered to this webinar, we're quite happy to give free checks, so you can try the system out yourself. And my colleague Gemma @legalbrokers.com, either one of us will be happy to get on the phone, provide a demonstration, and obviously provide some of those checks so you can see how they compare. Well, that's it from me, so I'll pass it back to Ian and let you get on with your webinar.
Thanks very much, Darren. That's much appreciated. Really interesting stuff there from Darren. Great products, three sort of distinct areas really to provide assistance to law firms. And as Darren said, more than delighted to sort of show you directly one-to-one the product. So if you're interested, arrange a virtual meeting with Darren, have a look at it. So we're also worth talking to Darren about some of the other things that legal brokers do. So he's got all manner of different aspects to the business, referral work, all sorts of assistance that can be provided to conveyancers in addition to this product. So ID Wallet is simply one element of a number of different elements that I think you as conveyancers might be interested in. So massive thank you again to Darren, massive thank you again to Stewart Title for inviting me along and for organising this event. Anyway, down to me, and let's talk about fraud and what sort of issues arise relating to fraud. What types of fraud are currently being encountered? Well, very interesting question. To be honest with you, who knows what fraudsters are currently about? Because what we tend to see as conveyancers are problems and nightmares after the event, when a property is repossessed, when the police are involved. So often we're way off the pace with regard to seeing criminality, current types of criminality. But what I can say with a degree of safety is that some of the old types of fraud, identity fraud, mortgage fraud, etc., certainly haven't gone away. What I class as communication fraud, interception of emails, phishing, etc., this sort of thing, again, just as common as ever. And the important thing is that we have to be so careful. As a conveyancer, we provide the perfect medium for washing dirty money that's been gained through criminality. If the criminal goes to their bank this afternoon with £500,000 in cash in a series of suitcases, then I'm fairly confident that the building society or bank manager would ask the person that comes into the branch to have a seat in a waiting room. They would then be questioned about where this money has come from, and unless proper proof can be established that this fund or these monies are legitimately obtained, then the police will be notified. The money confiscated, and our potential customer asked to explain to the police where this fund has come from. If they couldn't provide that it has been obtained lawfully with the appropriate evidence, it will be confiscated permanently and proceedings brought. So if, on the other hand, we send a bank transfer to our imaginary criminal's bank account or building society account, the building society or bank are not going to question us or our client as to the source of that fund. We legitimize illegal funds in those circumstances. So that's why conveyancers are targeted. And when I talk about being targeted, there's a myriad of different things that fraudsters can do in order to utilize the conveyancing process, from the pure and simple buying a property with ill-gotten gains, selling it swiftly, potentially even selling it at a loss, and then having monies in client account paid out from that client account, and all of a sudden those funds have been cleansed, to situation excuse me, where a fictitious transaction is created, deposit paid in as part of the buyer's apparent desire to purchase the property. The transaction, which is a private sale, goes no further. The deposit monies are returned to the intended buyer. Yet again, that's a nice, neat way of cleansing the deposit sum. So there's no intention ever for this transaction to go anywhere. There may well be a willingness to enable your fees to be deducted from the deposit monies before it's returned to the client, but nonetheless that process has huge value for the fraudster. There is, as a consequence of fraud, the risk of negligence claims. It's important to understand and appreciate that risk and vulnerability. If someone sustains loss as a consequence of fraud, the risk is that you, if you're acting for the seller or buyer, are potentially in the firing line for a claim. It is therefore essential to ensure that we take the risk of fraud seriously. It's important that we undertake the steps that our professional bodies require, and it's important that we undertake steps and measures that are reasonable in all the circumstances. As Darren sort of alluded to there, it is important to understand that fraudsters, criminals, are sophisticated. They come up with all manner of different systems, all manner of different approaches, and are quite inventive as to their trade or their skill, if I can call it that. And therefore, from time to time, a fraudster will trick everyone and get away with whatever they're wanting to get away with. We have to behave as reasonably competent practitioners, not perfectionists, not sort of the equivalent of MI5 with regard to our checks and measures that we undertake to prevent fraud, just undertaking that which a reasonable conveyancer would do on sale or on purchase. So there is a risk of negligence claims, lots of claims where lawyers have been held to be professionally negligent as a consequence of allowing fraudulent activity to take place. In addition to that, or on top of that, we've also got the risk of client complaints. The client that loses out as a consequence of fraud is not going to be happy at all with regard to our conduct or lack of it. So, first things first, when we're onboarding clients, there are some important things to ask. I would hope that you already ask these questions. One, how has the client found out about your firm? Let's assume it's a sale or indeed a purchase. We've got a new set of instructions from someone. We haven't dealt with this individual before or this couple before. Why have they come to us? Again, a reasonable question, and there may be a reasonable response. We've seen your website. Our friends or neighbours have used your firm. We've seen you on the high street, whatever. There may be other reasons why the client wants to instruct you. We've heard that your fees are very competitive. We've read an article that was written in the local newspaper. Whatever it is, but there may be a reason why the client wants you to act. In asking that question, it may be interesting to find out where the client is selling a property and buying another one, or where the client is indicating that they've been involved in the conveyancing process before. A supplementary question is, well, which lawyers have you used in the past? And again, not a cheeky question in my view, but is there a reason why you haven't gone back to that firm in connection with this transaction? Again, I'm just trying to extract from the client information that's fairly innocuous as far as the question is concerned, that might give me an inkling as to who this client is and what they are about. You know, if they've used a very well respected firm in the locality that we know, then why has the client decided not to use that firm anymore and have come to us? There may be a valid reason, there may not. Other questions to ask the client are issues such as, what do they do for a living? How easy is it to contact them? Asking all sorts of questions just to try and ensure that you are aware of your client's circumstances. Again, Darren touched on something, know your client is an SRA, Law Society, professional body mantra. I was reading just at the weekend about a case. I've read one already involving a matter before the SDT last September. I've just been reading about another one where exactly the same thing. A solicitor was suspended, I think, on this occasion for not inquiring of the client as to their circumstances, for not getting information about the client. Again, there was a capacity issue. That was a problem in the transaction. And again, the SDT's view was that steps and measures had not been taken to try and extract from the client what the problem was or the issue was with regard to capacity, and therefore the firm had not got to know their client. That lack of knowledge generated a major problem with regard to the transaction. The solicitor dealing with the transaction was therefore held to account by his professional body as a consequence of that failure. So gathering information, important. Remember, there's no such thing as a collective client. We are acting for individuals and must treat those individuals as such. It's important that we establish a relationship with the client. Some clients are used to the conveyancing process. They get it, they understand it. Other clients don't. They may be first-time buyers. Interestingly, I was talking to a professional indemnity insurer last week who was saying to me that if you've got a client buying a leasehold flat or apartment at the moment that involves the Building Safety Act, the client is a first-time buyer because they won't have dealt with transactions that involve the Building Safety Act before. And I think that's a good way of looking at things. So the elderly clients who have in the past always bought and sold freehold houses, who are now downsizing and going into sort of semi-sheltered accommodation, won't understand about leaseholds and won't understand about the peculiarities of residential leasehold ownership. We need to be careful. Clients' attitude to risk, again, important. Some clients are exceedingly risk averse and terrified about the potential in connection with the process and property ownership, in which case it's necessary to try and protect that client and to explain what steps and measures can be taken to avert or mitigate risk. All of these things are important. And when we're onboarding the client, we've got an ideal opportunity to, one, comply with our professional obligations, using, for example, any one of Darren's products, which he kindly shared with us earlier, undertaking manual checks, undertaking electronic client verification checks at the start of the relationship, but getting more information from the client that may hint at potential problems or issues, or may arm us with information that could be of use to us in the future. The important thing is, however, and this is my first critical point that I want to make this afternoon, there is a danger with electronic verification, with the likes of Darren's product that he kindly shared with us earlier. There is a danger that we deal with this when we're onboarding the client. We tick the box, we mark our online case management system that this has been dealt with, and then we get on with the task at hand, not thinking that property fraud, identity fraud could be an issue. The point I want to get over is no matter what we do with regard to onboarding the client and steps and measures to be AML compliant, to be fraud compliant, CQS compliant, and the rest, no matter what we do, that doesn't then mean that issues associated with vigilance, issues associated with being watchful and mindful of the risk of fraud disappear. They don't. We have to be constantly vigilant. So yes, we're establishing the relationship. Yes, we're getting information from our clients so that we can understand our clients, and so that we have an argument if any of our professional bodies say what steps or measures we took to get to know the client. We've done all of that, but that isn't the end of the story. Before I leave this slide, one or two other points. Point number one, nothing wrong if we've got a new client, nothing wrong if we've got a client that's out of our area to do a Google search against the client's name. Nothing wrong with just sort of undertaking additional investigation of the client where necessary. Again, we're required to undertake a risk assessment of the transaction, of the client, of the third parties. And to do that, we've got to know who the client is. So let me give you an example. If I was acting on behalf of Mr. and Mrs. Smith that come into the office this afternoon, and we've acted for Mr. and Mrs. Smith who live 200 yards away from our office, we've acted for them for the last 20 years. We've bought 5 or 6 houses or sold 5 or 6 houses on their behalf during that period. If we know them sort of personally as well as professionally, then they are quite clearly less of a risk than the 26-year-old disc jockey from Aberdeen that's instructing us in connection with the purchase of a high-value flat in central London for £7 million. So when we talk about assessing risk, we assess the transaction, we assess the client. Now, let's look at Mr. and Mrs. Smith for a moment. If we can determine that during that 20-year relationship, Mr. and Mrs. Smith have always been buying and selling semi-detached houses or their equivalent in the Wolverhampton area, and now they're buying a £2 million property in Padstow down on the south coast there, on the southwest coast there, then again, does that generate a risk issue? Well, if it's high value, yes. If it's out of area, yes. If it's not the sort of property that they have historically bought, then again, yes, there are risk issues relating to it. So we might have a client that we've acted for a long time. If they're doing something out of character, they're doing something unusual, then there's a risk element relating to it. Well, there's probably more of a high risk with regard to the client that we're dealing with at a distance, who's unlikely to be attending our office and who lives in Aberdeen, who's buying a property in central London and instructing us in connection with our firm that's based in Wolverhampton. So the important thing really that I'm trying to extract here is that there isn't sort of one system or one process that fits all. We've got to be able to be flexible. And this thing about questioning, this thing about gathering information, this thing about establishing the relationship, I think should be a moving feast, depending on client, depending on transaction, depending on our attitude and the client's attitude to risk. Darren mentioned the land registry's safe harbour concept. And again, this thing about verifying client identity is important. There is a standard that the land registry and government have created. You should be familiar with it. It's important that we comply with it as best we can. As the conveyancing process becomes more and more systematic, becomes more and more procedural, there is a danger that we distance ourselves more and more from the client. And my first slide, my introduction today, sort of is appreciative of the fact that that should not be the case. We need to get to know our client. We may have standard emails, standard reports on title, standard retainer letters, but there isn't such a thing as Mr. and Mrs. Average with regard to the client. And further, I repeat the point that where we are performing all the necessary checks that are required of us, of our professional bodies, when onboarding the client, that is not the end of the story. So, what sort of fraud could we become embroiled in? Or what sort of fraud could we see? What sorts of fraud are being perpetrated? Well, client identity theft has been on the books for a long time. It continues to do so. The land registry measures that are taken to try and prevent fraud work to an extent, but the fundamental problem with regard to client identity theft is the fact that our land registry system creates an open register, allowing anyone and anyone to investigate land or property that we own, enabling them to download official copies of the register, and allowing them to obtain information about the property that we own. In the good old days, within registered land, the title deeds were proof of ownership. Again, in a not so distant past, the production of a land certificate or a charge certificate was useful, a sort of formal document that a seller of a property would own. Well, of course, these days have gone, and we've now got an electronic register, which has numerous advantages, but has a major disadvantage in that the open register, the ability to download official copies of the register, is a problem. The second issue that we've got with seller identity or client identity theft is the availability of social media. A mere cursory examination of the National Crime Agency's website of Googling property fraud or conveyancing related fraud would generate lots of evidence as to how common identity theft is in the conveyancing context. And social media adds to the problem. Why? Well, the number of people that have Facebook accounts that have information, including the names of pets, perhaps including the names of parents, hobbies and pastimes, all manner of things that would enable the sophisticated criminal, either through guesswork or via intelligence or via computer programs, to generate potential passwords. In addition to that, social media and holiday snaps showing photographs of you and partner enjoying themselves in Bali on a 3-week vacation, again, is an indicator to burglars and indeed property criminals that you're away from the property for a spell of time, giving them perhaps a window of opportunity to perpetrate crime. So social media in all its forms and all its guises certainly doesn't help. And the amount of information that people are willing to reveal to what is potentially the world at large via social media is pretty scary. And then we've got sophisticated fraudsters. And boy, are some of those fraudsters sophisticated. They are switched on to opportunity, are switched on to the knowledge of the conveyancing process and walkarounds that will enable them to perpetrate fraud from time to time. Types of fraud then, what have we got? We've got corporate property fraud, the creation of companies to perpetrate fraud. We've got the potential for land registration fraud, applications for first registration of lost or missing title deeds, a great way of perpetrating fraud currently. In the good old days or bad old days, if title deeds were lost and you were submitting an application for first registration, the Land Registry would be pretty relaxed about that application and would ask for secondary evidence in support of title and not much more in order to grant some form of title, albeit perhaps a possessory title. Because of that, because of the availability of a fraudster saying it's my land, but I've lost my deeds and documents, can I be registered as proprietor? Because of the ease that that type of argument could be raised and a willingness from the Land Registry to assist, created lots of problems. Fortunately today, registration fraud of that type or that ilk is rare. The Land Registry's really tightened up. So unless deeds and documents were lost by a lender or solicitor or conveyancer who is willing to confirm as such, unless we've got secondary evidence to support ownership, unless we can show that we are currently resident or occupying the property, it may be that the Land Registry is unwilling to register anything at all. So the Land Registry is backed off a bit, but registration fraud remains an issue and we need to be careful. Seller impersonation fraud remains an issue and we need to be careful. What about mortgage fraud? Well, again, lenders are sophisticated and have all manner of different systems to try and prevent fraud, but a quick scan of the newspapers or a quick scan of the internet will reveal just how much mortgage fraud has been perpetrated and is being perpetrated. And what else is out there? Well, who knows? Certainly use of email, certainly the interception of email is getting more and more widespread. Fraudsters are getting more and more sophisticated, and as and when we, our professional bodies, the Land Registry, have systems and processes to stop other types of fraud, then other types of fraud or other types of activity are increasing. During COVID, the relaxation of working from home, the fact that we're not seeing clients as much, the high volume of transactions led to perhaps a resurgence in criminal activity. As and when they were back to normal, as and when people are being more protective of the conveyancing process, more wary of fraud, perhaps fraudsters are moving on to pastures new. But when things are tightened up in those fields, bet your life they'll come back to property on the basis that in the past it's been a happy hunting ground for them. So when I say what else is out there, who knows? All I can tell you is that where a lender or a client, a buyer client, sustains loss as a consequence of fraud, we are potentially in the firing line for our professional indemnity insurers meeting that loss. So undertakings. Again, be careful about undertakings. I've given you notes and details in the notes about the problems associated with undertakings and undertakings creating problems. Whenever you're asking someone to provide an undertaking, undertake a risk assessment. Is it safe to rely on undertaking? Do I know who this person is, who this firm is? Where I am really concerned about an undertaking and its enforceability, am I going to insist that an undertaking is provided by a solicitor rather than a member of the firm? Am I going to ask for an undertaking from the partner of the firm and a solicitor? The reason that you want an undertaking from a solicitor is the solicitor is an officer of the court, and therefore if there's a breach of undertaking, there is a further opportunity for recourse courtesy of that status. The general position really with regard to undertakings is you need to check the firm or the organisation that's providing the undertaking. Are they known to you? Is the person providing the undertaking within that firm known to you? Do you understand or appreciate their status? And I think the acid test, is the undertaking being provided for a promise to do something or not to do something, and the money involved in that undertaking is less than the professional indemnity cover that that firm carries. So in other words, if a firm is carrying £3 million worth of cover and you're asking the solicitors who are acting for the seller to give an undertaking to discharge a charge in favour of Santander for £12.5 million, there is a potential risk associated with that undertaking. So again, risk assessment. Is there an opportunity for fraud here? What is that opportunity? What is that vulnerability? What steps or measures can be taken to prevent it? So I've seen situations where a firm has been completely untrustworthy of the seller's firm who wants to give an undertaking in connection with discharging a charge. And in the end, the buyer's solicitors have agreed a scheme whereby they will discharge the charge directly to the lender, so that they have proof at the point of completion that the charge has been discharged, rather than relying on undertakings. Could the provision of undertaking be fraudulent? Answer, yes. Again, something we haven't mentioned and rather distasteful. Again, not uncommon for fraudsters to take a long-term view with regard to the potential for fraud in the conveyancing process. So let's recruit a trainee solicitor, a trainee conveyancer, an experienced conveyancer. Let's get them to join a firm and sort of embed them within that firm, and then use that position to our advantage. Not common, but equally not unheard of. Case law reveals with regard to undertakings that you do need to be careful, and could in certain circumstances insist that undertakings are provided by solicitors or partners of the firm, so that you are protecting your client as the recipient of the undertaking and your firm as the firm receiving it. As far as land registration and fraud is concerned, some basic points, and then we'll delve into one or two of the points made on slide. Again, the land register is an open register. Be aware that it is possible to apply for exempt information status for documents that you submit to the land registry. If that document contains commercially sensitive information, you can apply for exempt information status. You make application to the land registry and pay a fee. You submit the original unedited version of the document and a redacted version with the commercially sensitive information removed. If the land registry is comfortable that this is commercially sensitive information, your application will be successful, which will mean that if anyone wants to see the document, they will see the redacted version, not the original. Exempt information status does not provide blanket confidentiality for documentation. It is possible to make a Freedom of Information Act application to see the original document, and certainly the police and HMRC are entitled to make such an application, to which the land registry will not object. But exempt information status can be used to make sure that commercially sensitive information is kept out of the public domain. When the Land Registration Act 2002 went live, there were lots and lots of applications being made for exempt information status in a variety of different contexts. The Land Registry began to reject applications fairly frequently and fairly regularly, to such an extent that the concept of exempt information status fell out of favour. For the last 6 or 7 years, the Land Registry has been pretty relaxed about applications for exempt information status. So I do encounter practitioners that remember the old days where applications for exempt information status were failing, and who have stopped lodging applications as a consequence. It may be worth just revisiting that as a potential means of protecting clients. The other thing with regard to land registration as a general issue, before I delve into the details in connection with this slide, concerns the availability for indemnity. The Land Registration Act 2002, indeed the Land Registration Act 1925, promoted 3 principles: the curtain principle, the mirror principle, and the insurance principle. The insurance principle, the fact that the state would guarantee via the land registry the registered proprietor of a registered title. In other words, if there was any challenge or if there was any vulnerability to the title and the registered proprietor sustained loss, the proprietor could make a claim on the land registry. That indemnity is subject to the registered proprietor behaving reasonably. So where there is any form of unreasonable conduct, that insurance principle potentially will not apply and an indemnity will not be available. So if your solicitors have behaved unreasonably with an application for first registration, if you've omitted to provide the land registry with information that should have been provided on first registration, then you've not behaved reasonably, and the land registry's indemnity that could be available to the client will be lost. Further, if you have behaved unreasonably as far as rectification of registered titles are concerned, you have a right of veto. I think it's section 49 of the 2002 Act, in where someone is applying to rectify a title or your client's title. If your client has behaved reasonably, then they have a right of veto with regard to that application. That veto will be lost if your client has behaved unreasonably. I saw this in a situation where there's an application for first registration made. The seller of the unregistered land had notified the buyer that in the past had been a boundary dispute. The boundary dispute, I think, had gone away or had gone quiet or something, so it wasn't currently active, but there was a record that there had been a boundary dispute. The buyer buys the land, submits an application for first registration, doesn't tell the land registry about the historical boundary dispute. The land registry registered the title with an absolute title, and then out of the woodwork comes the neighbour that originally had dealt with or brought the boundary dispute, and the dispute is resurrected. The neighbouring landowner sought rectification of the buyer's title to incorporate some of the land that had just been bought into the seller's title. Now, that application for rectification would normally be subject to the registered proprietor, the person that bought the unregistered lands, right of veto. The land registry said, you've lost your right of veto because you failed to notify us of this historical boundary dispute. Now, I think from memory, I first came across this on the back page of our practice guide. The land registry gave examples of where rectification wouldn't be possible. And I think it's still on the relevant practice guide, but I'll have to dig it out, to be honest with you. So be careful. Anyway, land registry, very concerned about fraud. So what have we got? We've got a fraud line. We've got a property alert service that clients can subscribe to. Addresses for service, the first line of defense for a seller who owns registered land. Essential that clients keep addresses for service up to date. Essential that clients are aware that they can have 3 addresses for service, including the client's email address. The land registry a while ago suggested to the lay client that they should ask their conveyancer if the client could use the conveyancer's firm's address as an address for service. I haven't seen any reference to that in any land registry material recently. I'm delighted that that's the case, because I would never ever recommend to a firm that you provide the client with your firm's address as an address for service at the land registry. At first brush, at first sight, you might think that's a great idea for getting business, because it means if the land registry contact my client, they're going to contact me, and I can then sort of affect or reacquaint myself with the client. But the bad news is, if that were to happen and your client can't be contactable, but you have received a communication from the client from the land registry, that then creates a whole raft of potential problems. The way the land registry said this could be dealt with is that you have a protocol with the client as to what happens in circumstances where they're unable to make contact with the client. So keeping addresses for service up to date, important. Clients should be told about that when you are sending to them the land registry transfer, drawing to their attention the addresses for service that you have inserted, and when you are closing your file, it is essential that the client's address for service or addresses for service are again reminded to the client, along with the need for the client to be told that the addresses for service need to be kept up to date, perhaps explaining to the client the method for doing so. The land registry issued the double-L restriction some while ago now. Take-up has been pretty poor, to be honest with you. The idea of a double-L restriction is that a conveyancer is verifying that the seller is the registered proprietor. When the double-L restriction was introduced by the land registry, a lot of practitioners were saying, we're not happy about this because this potentially generates a whole raft of potential risk for us, where we are using a double L restriction, because then when our client is selling the property, in order to comply with the restriction, we're going to have to verify client identity. So a lot of firms were saying, we're not going to agree to this. These days, you don't see it that frequently, but nonetheless, you will come across double L restrictions from time to time. The important thing with a double L restriction is that it is not the conveyancer that lodged the restriction that verifies ID. It is the current conveyancer that is required to do so. And then finally, we have land registry guidance about property fraud. The land registry used to produce public guides, and I think it was public guide 14 that dealt with property fraud. That information is no longer available in a land registry public guide, but is available, I think, on government website. With regard to land registration, I think there are some basic points. One, explain to the client that this is an open register and therefore is accessible to anyone and everyone. Explain to clients the significance and importance of addresses for service, the point of contact between the land registry and your client, subject to fraud line or property alert services being used, and potentially detrimental to your client if the land registry are not provided with updates where addresses for service alter. The last thing I want to mention before I go any further with regard to this slide, if you're acting for a seller on the sale of registered land, when you download official copies of the register, it is essential that there is evidence on your file that you have cross-checked your client's contact details that they've given you against their addresses for service on the official copies of the register. So I've given you my address at 4 Coatsworth Avenue, Guildford, and my address for service at the land registry when you download official copies of the register is 1 The Meadows, Aberystwyth. You should be asking me, Ian, hang on a minute, what's going on? You've told me that's your contact address. The address for service that you've given the land registry is an address in Wales. Why the discrepancy? There may be a perfectly logical reason for the discrepancy. On the other hand, there may not. Certainly, that would potentially be suspicious. Talking of suspicions, we've talked already about getting to know clients, asking questions of the client, being observational as the transaction progresses, just seeing if the client is being consistent with regard to the provision of information. Perhaps we've got a buyer asking questions about planning permissions or about guarantees for central heating systems that were just installed, say, 3 months ago. And the seller client is saying, well, I haven't got any documentation. This sort of thing, although of itself not sufficient to send alarm bells ringing such that you're going to speak to your line manager or your compliance team. So this thing about getting to know your client is important. And the point I was making was this: it is absolutely essential as the transaction progresses that if there are little snippets of information that are being provided by the client, or where the client is elusive or evasive with regard to the provision of information, that the cumulative effect of all of that is that there is a suspicion. So, as I said, and I don't know whether you heard it, the buyer's asking for a copy of a guarantee relating to a new central heating system that was installed 3 months ago, and the client is saying, I haven't got it. Okay, well, that's odd, on the basis that it was only 3 months ago. It's an important piece of work that's been done on the property that's going to be invaluable going forward as a guarantee or whatever, and you've lost it. So that of itself might not be immediately a need to go running to your compliance team or your line manager, but there might be other things that are said or not said during the life of the transaction that have the cumulative effect that you now become suspicious of the client. With regard to corporate clients, do we do a company search when we're onboarding the client? Do we ask a director of a company to provide us with authority from the company to take instructions from that director? if the client that is contacting us is represented by a sales director, well, would that be appropriate given the fact that we're involved in a £4 million land purchase? Again, you'd expect the managing director of a company or an estates director to be liaising with a property lawyer. This sort of thing, again, can be significant. What's changed with regard to the law? Well, to be honest with you, not a lot has changed recently. Dreamvar and Pirancing, seller identity fraud. Both cases, the solicitor for the buyer takes the hit. In Pirancing, in particular, it was conveyancers for both seller and buyer equally liable for fraud that meant the buyer sustained a complete loss. Dreamvar, buyer's solicitors have professional indemnity insurance, therefore they can take the loss on the basis that the insurer takes the hit, not the law firm. Grondona, mortgage fraud, peculiar case. The solicitors that were sued by the buyer of the property also acted for the seller. The seller was boyfriend of the buyer. Both perpetrated a fraud on lender on the basis that there was a overvalue of the transaction and lawyers embroiled in the transaction. Again, important to check the position with regard to clients. Where client, seller and buyer are known to one another, that is an element of risk that needs to be taken into account. Where there's an undervalue or overvalue relating to the property, again, an indicator perhaps that further investigation or additional measures put in place to reduce risk. Mortgage fraud, again, a problem. If a lender takes a hit, the lender is going to have a look at your professional indemnity policy to see whether or not you've complied with the duties and obligations that you owe the lender. Section 61 of the Trustee Act 1925 provides a potential defence if you've acted honestly and reasonably. But have you complied with lender instructions? Remember, these days you are obliged to check your lender's instructions when you receive them, and are also obliged to check again just before you exchange contracts. Case law. The conveyancing handbook is potentially the defence to a claim in negligence against you arising from fraud. But there have been decisions of the courts over the years where the courts have said that the conveyancer's handbook is not a complete defence to a negligence claim. It could be, it isn't necessarily the case, however. Pirancing, a warning to conveyancers for sellers and buyers, cumulative bits of information not being provided, the seller client being wary about information that's produced, a previous buyer being unwilling to proceed on the basis that they were concerned about the seller's identity, seller resident abroad with little or no information about the property being sold, putting pressure on lawyers for both seller and buyer to get this transaction proceeded as quickly as possible. Dreamvar, the importance of identity checks when acting for the seller, the danger of asking buyer solicitors asking seller solicitors to verify client identity and then not getting a sufficient response with regard to the request that's made. Patel, highlighting that rectification of a registered title would not be subject to the right of veto of the registered proprietor where the registered proprietor behaved unreasonably. Before I have any questions, Robert, if you're still with us and if you can hear me, Robert, one of the things that I've spoken to Darren about in the past is your seller identity indemnity policy, which I think is really useful for buyers. If you could, and we've got a couple of minutes, if you could explain to delegates that have attended today what this policy is. The reason I like it is that it seems to me to be a policy that's of benefit to the risk-averse buyer, but probably it's more advantageous for the law firm representing the buyer in that it eradicates any potential claim against them. But if you could explain a little bit about it, that would be brilliant.
Yes, certainly, and you're right there. The essence of the Pirancing and Mitacon cases really were to throw liability onto the buyer's lawyer, who is probably the last person in the transaction able to give any guarantee as to the identity of the seller. And as you say, in one of those cases, it was purely that the court said, well, they've got insurance, let's hammer them rather than anyone else. So that is an unfair situation. And we were approached by lawyers asking if this policy could be created. So we have created our seller ID fraud policy. And in essence, what that does is where there's been impersonation of a seller, or where there's been undue influence or duress of a seller or joint seller, and property purchase price is paid over and is then lost, sometimes with a mortgage advance as well, then this policy will cover people. There is a maximum cover of £1 million on this policy, but it would cover you on there, and hopefully that would cover the majority of properties, I dare say, that we're dealing with. It does cover empty properties, so quite useful where there are probate sales and things like that, where that's often an area of fraud. It doesn't cover back-to-back transactions or ones where there's been a transfer or change in the details of the seller on the registered title in the last 6 months, because those are red flags that you should be looking for anyway. But if you have a normal situation where the seller, you believe it is the seller, money is paid over and you have a loss, then we will pay out up to £1 million. The advantage for buyers and lenders in particular is that you don't need to prove negligence on the part of the buyer's lawyer. You need to prove the claim and then get a payout. And because it is, as you say, intended to a large extent to protect lawyers as much as buyers and lenders, this policy we have expressly waived our right of subrogation against the buyer's lawyer. So a claim can be made on it in safety there. The premiums start from £28 for cover up to £250,000 and finish up at £67.20 for £1 million worth of cover. So relatively cheap. It is often, although of course difficult to get clients to pay out any more money in a transaction. So the angle that we have put on this, I think, thing to express to clients is that unlike most of our policies where we're looking at a diminution in market value, say 5–10%, this is one where the whole of your investment in the property plus the whole of your loan will disappear if there's successful fraud. So for that sort of cover and the potential liability, I think the premiums are quite good there. We do have information on it. If you speak to legal brokers, they can provide you with details of the policies and the assumptions which you need to meet there. And happy always to discuss with anyone how the policy works and how you can buy it.
Thank you for that. Thanks, Robert. If you're interested in seller identity fraud, there's a great paper written by a barrister called Nick Taggart called Who Do You Think You're Kidding, which is available on the Property Litigation Association website. He sort of goes into the law. But I think if you explain to the client, and I wonder whether you should always explain to the client about, look, there is a risk with regard to the purchase of a property, that there is seller identity fraud that could be problematical, and you've got a client that's absolutely terrified about it. What can you do to reduce or mitigate against that risk? Well, the seller is not going to give you, if they've got any sense, warranties to verify their client identity. They're not going to do that. So that I think your fallback position has to be the availability of an insurance policy. And as Robert's just kindly explained there, the level of premium and the potential protection, I think, is cracking value. Anyway, I'm conscious of time, and I'm conscious of the fact that people have been attending today. So 2 or 3 things. First of all, tomorrow I'm doing some Building Safety Act issues. If anyone's interested, please come along. Also, probably Law UK. Also, I'll go back to the very beginning and just show you some contact details if I can. First of all, Robert's contact details are shown there. If you want to contact Darren with regard to his products, then please contact Legal Brokers or contact me, and I'll pass on the details to Darren. What I'd like to do is once again thank Darren for attending today and explain to us his ID wallet product. to thank Robert and Stephen Smith from Stewart Title for attending today and being supportive of this event, and to thank you all for attending. If anyone has any questions or queries about anything I've said, if you'd like any further information about anything I've said, feel free to drop me a note by email. But on that happy note, thank you very much for coming along today. I hope you have a very pleasant remainder of the afternoon, and I look forward to hearing from you in due course if you have any questions or queries. Thank you, everyone. Thank you. Bye-bye.